ওয়েলকাম ফ্রেন্ড, আপনারা সকলে জানেন আজ 19শে ডিসেম্বর বৃহস্পতিবার মহামান্য সুপ্রিম কোর্টে প্রধান বিচারপতির বেঞ্চে 2016 এসএসসি নিয়োগ মামলার শুনানি রয়েছে। আজ 10:30 থেকে এসএসসি মামলার শুনানি শুরু হয়েছে। বিভিন্ন পক্ষ তাদের বক্তব্য রেখেছে। আজ যোগ্য শিক্ষক শিক্ষিকাদের পক্ষ থেকে ডক্টর মনু সিংভি এবং কপিল সিব্বালের বক্তব্য এখন আপনাদের শোনাবো। ডক্টর অভিষেক মনু সিংভি এবং কপিল সিব্বাল আজ সুপ্রিম কোর্টে প্রধান বিচারপতির কাছে কি বক্তব্য পেশ করেছে এখন শুনে নিন।
Now just turn to page 92 of volume 6. I'll read 5 paras only. I'm done. 7-8 minutes.
Yes.
Rashmi, got page 92?
Yes.
Now, the petitioners were bona fide applicants to a public advertisement for recruitment in 2016, participated in a competitive examination, received the recommendations, and were issued appointment letters. They were appointed validly and remained in undisturbed service between 18 and 19 prior to the expiry of the panel in December 19. We are class 9-10 and class 11-12 out of 4 categories on these assistant teachers which I have given in para 2. Para 3, no adverse action has been taken against me. This is very important. During the course of hearing before the Honorable High Court from 2021 onwards, until the in-rem direction was passed in the impugned judgment. It's going on for the last 3 years. Further, the petitioners did not feature in any of the list of tainted categories. Justice Kumar asked a direct question. I'm giving an unequivocal answer. No category, no list by any entity. None. That were filed from time to time by CBI and the West Bengal Central School Service Commission before the Honorable Court, underscoring the soundness and legitimacy of the appointment and tenure. Thus, despite there being sufficient material before it to identify and separate the tainted from the untainted, such as the petitioner, the impugned judgment erred heavily by painting all candidates with a broad brush. Prior to the impugned order, I am nowhere in any list. It is also crucial that a vast majority, I am 10,000 persons working from 2018. Now, let us kindly come, and as I said, I'll be just come to para 15. I'm skipping most of it. Well, I will come to para 15 now.
Yes.
The appointing authority and the recommending authority have taken a decision to sustain the entire selection. The expert body involved in the recruitment process found it fit to separate the tainted from the untainted. Why, Malas? For a very simple reason in my case, which is given in para 16. There are 3 lists made available by the board and the CBI. These are the list of 775 candidates, revoked using Rule 17, both 9-10 and 10-11 classes. List of 942 whose OMRs were found by irregularities, nowhere on the list. I am nothing of this. List of 907 whose OMRs were found with irregularities for 11th and 12th. The first list pertains to the independent exercise carried out by the board of classes so-and-so. And this, Your Lordship knows, Balas. Next, 4th line. Notably, the CBI had filed an investigation. This is very important, Lordship. Underline this, Balas. Saying that the investigation relating to all 4 categories was complete and charge sheets have been filed. So they found those 4 categories. I'm nowhere there. It's over. Then, even before the High Court, as far as illegalities are concerned, Your Lordship, I made a table. Your Lordship has heard the OMR manipulation issue. Your Lordship has heard the OMR issue. Your Lordship has heard rank jumping. Next page, page 94. My Lord has heard expiry of panel. And my Lord has heard beyond the advertised post. I am nowhere, completely, unqualifiedly untainted. Para 19. In fact, the High Court acknowledges in para 329 that the percentages of manipulated illegally appointed persons across the categories other than Group D are on a reducing stage. There were no other information available before the High Court. It's only the High Court which has done it for us. Nowhere have I been touched earlier in any. Now, just 2 minutes more, Balas. Item para 3, big Roman 3. Under that, Balas, High Court makes no effort to separate the tainted from the untainted. Comes straight to para 22. Para 22. The High Court, this is a blanket approach, Balas. Throwing the baby out with the bathwater. Completely blanket. The High Court proceeded with option C. C is the cancellation of the entire selection process. Your Lordship, I would say, are obliged to do B if Your Lordship finds the untainted category, which the High Court did not do, is my humble submission. The only reason to cancel the entire selection according to the High Court is because it is difficult to separate the chaff from the wheat. That's the main reason given. However, no effort is made by the High Court to separate the tainted from the untainted, despite abundance of material available. In Karo's case, this court laid down a standard of absolute impossibility. I've given that at page 40, para 43 of that judgment. Only in case of absolute impossibility. Convenience is not a defense. Careers of 10,000 in my class will be spoiled, and the answer can't be it's inconvenient to separate or segregate.
Yes.
Then 24, the aforesaid list provided by CBI and the board have not been adverted to. Well, if the High Court is passing a blanket order unseating me, then it had to at least say that list 1, list 2, list 3, list 4. Where are you, Mr. Singhvi? No exercise, Willis. Para 25. In para 325 and 336, that is one of the whole bunch of paragraphs, High Court holds that the original OMR sheets are not available with the board, and therefore an exercise of sifting the grains is not possible. Is it somebody's fault if the original is not available? You have enough material from the CBI. How has the CBI made the list then, Willis? How has the board made the list? They could put up the hand and say, all 10,000 of you get out because we don't have the original. That can't affect my career, Willis. I'm completely outside the system and completely blameless, Willis. Then, Willis, in para 29, I've dealt with Kahlon's case, which I've already made. I'm not reading it, Willis. Along with Kahlon's case, I've given 3 more judgments, Willis. If you're, as a matter of fact, it's a grave miscarriage of justice. Your Lordship has material to not punish the innocent. You will not blanket, Willis, club me with the guilty and throw me out. That's these 3 judgments, Willis. Kahlon is the 3-pronged test. It's very important, Willis. Your Lordship juristic principle is the 3-pronged test of Kahlon. 1, 2, 3 I have given. I'm not reading it to save time. The 3-pronged test is very clear. The High Court doesn't apply any of this 3-pronged test, Willis. And then lastly, Willis, is para 33 onwards, where it clubs group C, D, and everybody else. I would in conclusion say this. Your Lordship is going to be allowing a very grave injustice to be perpetuated if this kind of clubbing and blanket approach is allowed. You're here, fortunately, you have an individuated approach. Yes. Lastly, one thing, only one minute more, only less than a minute. Para 30, I forgot to read, Willis. Just note 30. That's the 4 lines of 30 are very important. There are no findings in this regard as far as the majority of appointees being involved in the so-called illegality.
No, that's irrelevant.
No. Next sentence. As far as teaching staff is 8% and 14% are found.
No. 1 minute. That's not the point. What the argument you are raising is until this malifieds are attached to me, that's the argument you're raising.
That's the basic argument. I'm not at all involved in anything.
That's a separate argument. Even if we are not able to, that's an argument, even if we are not able to bifurcate the tainted and untainted, then even apply the principle that if I'm not involved, then protect me. That will be difficult to accept.
Mulad, I just, Mulad, 1 second.
List of tainted candidates, my lord.
I'm appearing in 1.1, Mulad.
Even if we accept that argument, then in all cases where there's gross irregularity or not gross illegality in appointment, and we are not able to segregate the tainted
but-
from the untainted, you will create.
No, Manas, the first objection is that there is a material to segregate. The
Manas,
three lists are there.
Okay,
Those
the
three
core
lists are there. What else do you need to
That's the
segregate?
core- that's
Manas, may I just,
Manas, in 4 years, would the CBI put me in some list? Would the board put me in some list? Would the SSC put me in some list? Whereas I can't prove a negative, Manas. They've been doing lists for the last 4 years.
Manas, just I'm appearing in 1.11. I'm in the same category as Dr. Singhvi's client. Manas, I just one small submission make it take 30 seconds. Manas. And that is that the CBI has got, Manas, the material from the hard drive. Having got the material, they have segregated themselves because they have, Manas, said that 92% in 9 to 11 are not tainted, but 8.24% are. And as far as 11 and 12 is concerned, 14.57 are, 86 are not tainted. So the CBI has done that exercise. And having done that exercise, then, Manas, we can't be punished. And I'm in the same category. And the rich court, what it does is it takes C and D categories, the other category where it is 30% and 40% tainted, and clubs it together. Instead of the 19,000 people, 8% or 14%, I'm going to take an average of 12% are tainted. You will throw out the other 88% because 12% are tainted.
Please, on that basis of difficulty, we have understood your argument because CBI itself has bifurcated.
Bifurcated, correct.
Yes, they have
Not
done.
that.
That's
But
what we
I am
want.
in the same category,
all,
my lord. I am in the same category as that of Mr.
That's all.
Singvi and Mr. Sibal, my lord. Only difference is Group C and D I represent, my lord. My SLPs are right on 1.5 and 1.13, my lord. My submissions are at page 100, volume 6A. But my submission is that, like your lordships have noticed, from para 288 till 309 of the impugned judgment, the High Court has taken note of the segregation information that has been given, my lord. In none of the reports that our names have figured. We have been appointed in the first list in April 2018. From then, there is no material, nothing, till the impugned judgment. We have not been called upon to do anything. Our name is not mentioned anywhere else. Now, the point here is, if the High Court holds that the information is admissible and we have got enough information to segregate the names from the tainted ones from the untainted, and if this kind of direction at page 272, para 363, the direction number 4 will say that persons who had been appointed outside the panel after expiry of the panel, as also those who submitted blank OMR but obtained appointments, must return all remunerations and benefits received by them in the state exchequer along with interest, etc. My lord, if this kind of information can be taken and their appointment can be set aside with the same kind of information, my lord, how can the item 2 order can be passed, my lord? All appointments granted in the selection process involved is violative of 14 and 16, so all are declared null and void. So this direction, number 2, my lord, cannot stand because there is enough material with the CBI and also, my lord, in all the affidavits which are placed before the High Court, which your lordships have seen. And secondly, my lord, like Mr. Singhvi was pointing out, my lord, in the Singh column really says, my lord, there are 3 tests which I have extracted in para 2.3 of my submissions, which exercise has not been undertaken by the Honorable High Court, which says, my lord, just I'll read this. If the services of the appointees who had put in a few years of service were terminated, compliance with the 3 principles at the hands of the state are imperative. That is, to establish satisfaction in regard to the sufficiency of the materials collected so as to enable the state to arrive at its satisfaction that the selection process was tainted as far as them. To determine the question that the illegalities committed go to the root of the matter which vitiate the entire selection process, such a satisfaction as also sufficiency of the materials were required to be gathered by reason of a thorough investigation in a fair and transparent manner. Whether the sufficient material present enabled the state to arrive at a satisfaction that the officers in majority have been found to be part of the fraudulent purpose or the system itself was corrupt. None of these, my lord, have been carried out. And para 93 says, it is one thing to say that having regard to the nature of the selection process, no person is appointed from the select list as no person has a right to be appointed only because his name appears in the select list. But in our opinion, a different standard must be adopted for terminating the services of the officers who had completed about 3 years of service in that case. Some of them, as noticed herein before, passed departmental tests. Some have been given higher responsibilities. They had completed period of probation and some were nearing the completion thereof. They presumably had been working to the satisfaction of the authorities concerned. Same here, my lord, from 2018 we have been continuing in group C and D. No action against us, my lord. Till date, no names have come out, my lord. We have all altered our position in the society. We have improved our lives, my lord. Our lifestyles have changed. And we have, some of them have entered into family and not created loans, etc. Their rights will have to be protected since they have not been, my lord, a part of any of this. Even, my lord, in para 2.5, my lord, at page 100 of volume 6A, the judgment in Rajesh Putanvalli Kava will say that is of significance. It's humbly submitted. It's not a case where massive fraud is said to have permeated the entire process since its inception or in the conduct of the examination itself. Furthermore, the untainted candidates, including the petitioners, stand to lose their job after having worked for 6 years without compliance of Article 3.
Okay.
Malats, I appear for the.
That was a bad committee.
Malats, I appear for the.
There is
ELP is standing on his legs over
I have only praised. Just one thing. For a 3.3.
My arguments have been raised, not only small.
This will give.
There.
Create,
You have understood your argument.
Malats, I appear for the.
since the material is already out.
Malats, I appear.
At best, my lord, there can be a committee which can be appointed if your lordship so desire, my lord. I have suggested
Can I say something? No, I'll not repeat anything.
a committee of the retired judge of this honorable court with a technical expert from NIC.
Okay,
Some
okay,
retired
fine.
member from the
Okay,
No, no, I'll take only 1 minute.
Our appointments have been protected is my
The
prayer.
untainted category which Dr. Singh addressed your lordship on. There are 1,800 people approximately out of 12,000 who have actually given up government jobs and come here. And so our written submissions are at page 49 to 54 of compilation C. So, my lord, please see the inequity for us. Untainted, not in any list, not named by anyone, and given up government jobs to come to better our career prospects. And now we are faced with this difficulty.
Malats, I